we are here. And tonight, I've been excited. I've been waiting all week for this because actually I met Al Nicoletti almost a month ago now in Clubhouse. And the very first time he made an appearance in there, he just impressed me to like no end. So I just followed him right away. And every time he got in a room, I jumped in there. And I think he also did the same for me. And we just ended up kind of getting a little friendship going there because we were like on the same plane. And he so totally understands the investor mindset, the investor goals that we're trying to accomplish and everything. And sometimes for attorneys, that's kind of a hard leap sometimes because they're not totally in our space. So I was just really, really happy to finally meet somebody that I could really gel with on the subject. And so I asked him to come on here so that I could kind of ask him some questions about what we all go through and what you're typically going to go through in the land business, in the land flipping business per se, and very specifically in our little niche. So we're dealing with smaller properties, and we don't really deal with homesteads. So I know Al knows everything there is to know about all types of probate issues and heirship issues and everything. But I've asked him to just kind of narrow that scope just to basically what we do in our flipping business with land, which is typically not homesteaded. So Al, thank you so much for joining us tonight.
John, thank you so much for having me. I'm so excited to be here. When we first connected on Clubhouse, that was unbelievable. I had no idea what the app was. I didn't know what it would do. And I didn't realize it would connect me with someone like you that's not necessarily in Florida, but just a big time investor, And as I've talked about that in groups, I love investors.
Well, I really appreciate you being here. And maybe if you could maybe introduce yourself a little, tell us a little bit about your background before we kind of jump into things here.
Yeah. So my name is Al Nicoletti. I'm an attorney here, licensed only in Florida, but I do probate. I love doing probate. I think it's a fascinating niche. I do quiet titles where there's maybe a tax deed or a quirky issue in the title that needs to be solved for title insurance, or partitions forcing a sale. We can always talk about that, John. But my background really started when I was in Miami. I had just come out of law school, right? When you come out of school, you're always looking for anything and everything to get experience in. So I said, I don't care. I just want to get hands-on. I want to see what a book is. I want to see, what are these motions and orders and getting into court. So I had an old family friend that helped me get into it, Dennis Haber. And Dennis just showed me the ropes hands-on in the beginning. And I learned a lot about foreclosure defense. So it wasn't even probate at that time. And it was kind of at the end of 2008 era. There's tons of case law on it already. It's pretty, simple. It's going to get cash for keys at some point. It's not going to trial. But at some point during that time I was there, one of my best friends, Jesse Stern, he came down to Miami, visited me, and he was telling me all about this probate thing. And when we were in law school, he was working for a firm that did all this probate stuff. But back then I didn't care because I was just in school. All I was trying to do was get grades and graduate, right? And pass the bar exam. So at some point he had come down, he was telling me all about this niche, this probate niche. And I'm like, I still don't get it. I still don't see the big picture here. And I think it was a year later that he came down again. We talked again. He was like, have you done anything about it? And I was like, no, I can't. I could try. I'll get into it. And I finally realized what was going on. And what was happening is that there's so much property out there where title is still in the name of the deceased person, or there hasn't been a probate yet. And we'll talk about the different leads, John. But it was then at that time, the light bulb went off and I said, wait a second, you have 67 counties in Florida. You're talking about how many properties that still haven't had a probate issue done or a probate done, and title is just in limbo. So a buyer comes along and there's a probate issue, and it just clicked. And I was in Miami then. Jesse was up here in Jacksonville. I got a job opportunity to come up here. So I came up here, and he even said, he was like, if you do this niche in Jacksonville and not Miami, you're just going to crush it. And I came up here, I had the message, I just did it. And it exploded from there. And I think it exploded because of what you and I are doing right now, John. It's sharing values, ideas, it's sharing content, it's being and promoting and being out there for people. And that's what made the difference. Not even initially when I was here in Jacksonville did it work. It only started working when I was speaking and I stood up in front of a classroom and I said, have you ever heard of this concept? Did you know probate can take 2 to 4 days? You don't have to wait that long. Did you realize that we can wait until closing to get paid? This whole niche you've heard about. And I think then the whole thing took off and everybody was in on it.
Oh, that's amazing. And I'm glad you did. I mean, I'm glad all that happened because I think it put you like in a perfect place. And now here's the great thing about it. I mean, we're really faced with the baby boomer, my generation. We're coming to, our end times. And so, as they exit, there's going to be even more probate issues and more property like that that's going to be out there that investors are going to be needing to deal with and to handle. And so let's get, let's get our hands around it and kind of figure out, well, what can we do and what are our options? But before we do that, just so everybody knows, I mean, Al is a licensed in Florida. So, I don't know if you want to give a quick disclosure because we're talking to people from around the world actually here.
All right. So I'll do it because I already have one. So
okay.
This post video / whatever presentation does not provide legal advice and is not intended to create an attorney-client relationship. The matters discussed in this video post and informational session is educational and informational only. And I'm only a license in Florida.
Okay. Now, with that being said, let me massage that a bit. So I noticed that like in Texas, my probate laws and stuff like that are very similar to yours and very similar to actually most states that, they obviously there's differences in every state, but how much of a difference, when we're talking about like some basic concepts, affidavit of heirships, tenant in common, stuff like that.
So, well, I don't know what a lot of states do. I have heard those things with like Texas, that there's a way to avoid probate there. If you get everybody on board, I have no idea. But a real dive in on the probates in Florida is what is it like in Florida, I guess, with probate and the fact that how is it different from other states? So I've heard a lot of people say that we are blessed when it comes to a Florida probate state because Texas is probate friendly. I think California is somewhat probate friendly. I think it takes like $1,000 to even like start a probate in California. But when it comes to title in Florida, you can't avoid a probate situation, right? So the only times you can probably maybe, if anything, avoid it is a partition where like you have A and B on title and A wants to sell, but B's dead and nobody has a clue where anybody is. Yeah, you could force the sale out from the estate, but you have tenants in common here, right? A, B, C, and D, they own equal interest. We could get really deep, but I'll keep it simple. Then you have the other deeds with the rights of survivorship, where it's basically what they don't tell you in law school is it means survival of the fittest. Whoever lives the longest gets the title to the property, and you avoid probate along the way until that person dies. And hopefully they retitled the property, but if they didn't, then they need a probate and they're heirs. So you have these different functions in Florida where you can avoid it, but for title insurance in Florida, you can't avoid it. And that's where Texas is a little different, where you have that affidavit of heirs or that heirship, because here you can't. And the reason is that I think because of maybe a public policy thing, I don't know, but maybe because there's a lot of retirees, they want to make sure that there's the right heirship in Florida. Nobody's missing anything. Title insurance doesn't want to take a risk that, an heir was left out when they do it so that the heir comes back and claims. But you have interesting situations in Florida.
Okay. Well, that makes sense. So basically if somebody passes away in Florida without leaving a will, you still have to probate the estate.
Correct.
Is that what you're saying? No
Oh,
affidavit
absolutely.
of heirship is allowed there. So what does that process look like? What are they having to do?
So something
And let me box this in a little bit more. Let's say the person died many years ago, so over 2 years ago, because that's typically what we find in our situation.
Well, what I tell people and I put in my PowerPoint all the time is that if its date of death is more than 2 years in Florida, even faster, even better, not even because of the heir situation, but there's a concept where creditors have a right and a try to make a claim against property, or if it depends, if it's homestead, they can't really, but if it's less than 2 years, they could try to make a claim as an attachable asset. But when you have these things that are more than 2 years, Visa, MasterCard, Home Depot, Comcast, Phillips and Cohen, Ascension Point, they're all out. They can't make the claim. So you have a simpler process where you're not dealing with that, or I'm not dealing with that, and we're not having to find out the mail and everything. And what I learned in 2020, John, in Florida, was that title insurance underwriters are willing to move forward on a deal on title insurance when there's an order of summary administration. What does that mean? It means simple and easy. I didn't know that if we could do what they call a simple probate and title moves to the true heir. So mom died, she had this land in Lee County, Florida. There's two heirs. We didn't know for a long time when that policy changed with title insurance that we can do a summary administration, make it move over to the two kids. They're on the order, they're on title, and we're done. So when you want to know the process, you can make it that simple. And that's the thing I learned in 2020. I don't want to make these things any more complicated than you do, John. I want to make it so we get in, we get out, we're done. I'm not here to dilly-dally in it. So we can figure out, wait a second, date of death is more than 2 years. It qualifies for a summary administration in Florida. Sure, there are some exceptions to why we would do a formal and all of that stuff, because maybe there's some bennies that don't agree or won't sign. So we need to appoint somebody. But the process in Florida, it could be 2 days. I think Hernando County. So Hernando County was my fastest probate. Not all results are the same. Every probate can be different. Hernando County, I did it in 2 hours, John. Why? Because you find out as much as you can. You find out who the heirs are. Mom died 20 years ago. I think her probate was already done in another state. Nobody found out there was this property here in Florida. And so what ended up happening is an investor found it. They wanted to figure out what they do. And we found out there's just two kids. They both were alive. They were both on board. They were willing to sign deeds later at the title insurance company. And so what did we do then? We're like, wait a second, let's just do a summary. Let's just get this done. Let's get all the information, get the death certificate. I filed it at 2:00. I got a court order at 4:30, title insurance. And now it's not about the probate anymore. It's about the title company closing it. You know, everybody used to think, oh, it's the probate, it's going to take 9 months, you know? So it's about efficiency. And the
Okay.
same thing is in Clay County, 1 day, Nassau, 2 weeks, Tampa, 1 week.
So let me ask you this, and using this example, because this happens to us, right? So what happens when the person has their property, let's say in Florida, but they've been living for a while in some other state. They die in that state, buried, their probate and everything is done over there in that state. How does that, what do you have to do then in your state?
And that's what we learned in 2022. So not 2022, but 2022. So what we found out was there was a way that we could bypass the issue. So mom dies out of state. And the question was there ever a probate, or is probate done? And if it's either or, there may be a way that we just have to do an ancillary, what they call ancillary, meaning it's the secondary probate here in Florida. And it would be the same procedure.
Okay.
We don't have to do this, open this thing up in another state. So great example, Lee County, same thing. Mom died out of state. Nobody realized she owned this land in Southwest Florida. And so all of a sudden, investor finds it and says, hey, there's Al Nicoletti. He does all this probate stuff. So when I found out the whole story, we were always told you have to open a probate out of state in order to then have authority in the state of Florida. Well, what happens with attorneys? They don't respond. They don't get back to your email. They don't do anything. So the guy sat on it for a month and a half, never even returned my phone calls. And I said, you know what? Let's try something here. I tried it, John, in 20 days using FedEx and mail because they still weren't doing e-filing or anything. 20 days, done, court order. Yeah, I'm telling you.
Wow.
This is different. You can get around it if you have the right stuff.
Okay, so let's say, for example, we have we find a piece of property, and now we're dealing with a surviving spouse. All right. So in that case, what is it that we should be looking for or asking that person, like right there on the phone, to kind of figure out if we actually have a deal or no deal?
You ready?
Yes.
Okay. I've had this twice in the last 3 days, and I read the statute again. So in Florida, 2 types of things. You have homestead and non-homestead. We're not going to talk about homestead because that's a CLE that Al Nicoletti won't be doing for a while. So we'll talk about non-homestead. Non-homestead, it says a husband dies, leaves a spouse. The question is, are there children with the spouse and the husband? So no children, 100% to spouse. We're good. You have spouse on the contract and or on the deeds. Then if you have children of the deceased and with the spouse, 100% to spouse. So now you're still looking at spouse. Number 3, the deceased had children with the spouse and or no children, but had also children from a prior relationship. 50% to spouse, 50% to the children of the deceased. So what does that mean for contract purposes? Spouse and all the rest. What does that mean for title insurance? Spouse and all of the rest have to sign deeds. Now, number 4, the one that I heard about recently, I was like, what? So a spouse dies, a husband dies, leaves a surviving spouse. They have children together, but the spouse has children of her own. Number 4 says 50% to spouse, 50% to the kids. So why do I tell you that? Is because you get to a point where you really have to ask questions. They may not tell you the story because a lot of heirs don't want to tell you their whole family history. They either don't want to tell you they're around, they didn't show up at the birthday party, they weren't around for the concerts and stuff. So they just want to say, oh, he wasn't around, he's an outcast, right? But the problem is it matters. It matters for title insurance. It matters for title claims. You don't want something later coming up. So you have to ask the right questions about who's around. And if you really get it down in Florida in the beginning stage of land that there's a spouse, you got to ask, are there children of either spouse or either husband? Because it matters for distribution purposes. So I picked up one today. It's a house, non-homestead. Oh, it's wacky. It was 5:00. I was just in the office. I was drawing the whole thing out. But basically, husband dies, leaves, spouse survives him, then dies. But when the husband died, he also had a kid from a prior relationship. So when that happened, the 50% kicked in. So then spouse deceased gets 50%, her estate would get 50%. And then his other kids would get the 50% distributed. Well, of the 3 kids, one of them predeceased him. So when that happens in Florida, you immediately look down the line bypassing their spouse. So they had 2 kids. There's another kid out of the country. So all of them have to agree, right? Well, you want that because a formal and getting a PR is going to be a mess. But then you have to figure out the other side. and that's deceased spouse of the 50%. It's a double probate. So if her side, thank goodness, the two kids from the husband were alive and they are the heirs of her. So, John, real estate probate is just another real estate transaction with a puzzle. And figuring out the whole lineage the best you can is the most helpful you can be.
You know, Al, that's exactly what we do when we're talking to the seller. So as soon as they give us this, my spouse has passed away, or if I'm talking to a son or a daughter and they're saying, well, I ask them, who is it titled in? So that's an important question. So I can be talking to them, but I got their name from the tax rolls, and the tax rolls doesn't always mean that's the owner of record on the deed. It just means that's who is being billed for taxes right now. And so the questions I ask almost in a row is, are you on title or is somebody else on title? I'll also ask this, are you, besides yourself, now I could be talking to anybody, but besides yourself, is anybody else on title? Because I want to, I want to start getting that full picture for this very reason, for probate and heirship type issues. And so when they start telling me, and now they kind of open up. So I ask easy questions first, which then I'll only go so far, because as you just aptly put out mentioned, they don't want to share everything. But if you baby step them, then we can baby step in and kind of figure out, okay, we know kind of what we want to do. And I love these deals because that means that so many times no other investor is going to step in there and do this deal, because as soon as they start hearing this stuff, they think it's just massively too much to deal with. And we deal with it all the time. And it's just part of our business. And the great part is it just leaves more business for us. So when you have somebody on your team like Al to come in there now and kind of take over at that point, now he's also instructing you, okay, this is what we need to do. Or what do you do when somebody comes to you and say, well, okay, so I've got this lead and I've got them now. I've even got them under contract. Maybe, they contracted with the person they're talking to, because that's really kind of the starting point a lot of times. But now we have this issue. What are you saying to the investor when they call you and bring you at this very point? What's the steps from there?
If the heir reaches out, we can figure out the puzzle.
Okay, yeah, and I'm going to assume that they're willing to work with you. However, so are you directly involved now with the heirs and talking to them?
At that point, yes, getting the big picture, or it may be a family member, like the one I was explaining, where the family member is kind of involved and knows the story, because sometimes the heirs don't know. They're in their own world. They may be in school. They may not be living the best life, but then you always have that one relative that knows the whole story. And then this one did that, and then this did that. And I don't need to hear the whole thing. I need to hear the line and who's next in line. So in those cases, exactly, John, if all of a sudden you emailed me and you were just like, I think there's some possibility here. If that heir reaches out at some point and I'm able to listen to the full story and I can break down the probate scenario, not the taxes and everything, but the probate scenario, we can figure out, is this going to work? Because at the end of the day, the way I structure it is just I wait until closing to get paid, right? So because of that, it almost forces me to really think through from beginning to end about how this whole thing is getting done. Because otherwise, nobody's getting anything. So I need to hear the whole story. And like you said, it really boils down to the deed and who's on title, which is why I always stress, and I tell it all the time, because you'll get even seasoned investors that they do so many deals, they overthink it. Title commitments. Title commitments are your best friend, because why? Don't depend on just the last deed recorded. I've seen stories and situations where the last deed may say what it says, but the whole other deed chain behind it is all messed up. I mean, you got to X, but to get to X, it was A to F and F to S, and it's just all over the place. So title commitments are important because they tell you the bottom line, who's on title, what did title insurance not like, because you can't close the deal without it, And so it helps a lot. It does. It really helps with equity.
Perfect. Can you explain to us the difference between tenants in common and joint tenants with right of survivorship?
So tenants in common in Florida means equal interest of ownership, or it depends on how much that ownership interest is. But basically, it's a divisible interest. So for example, Al and John are on title. There's no magic language on the deed. It just says Al and John. And so one day, John says to Al, Al, I think this property is completely useless and worthless. I don't know why you like this. And I go to you, John, and I say, are you kidding? Florida is the next gold mine. The property values are going to be soaring. This is going to be commercially zoned one day, and we're going to make a lot of money, right? I don't even know if that happens. And then you say, no, I don't think so. And, there's a concept called partition, but we don't have to dive into it. But let's say like Frank comes along and you're like, I got to get rid of this interest. I don't want to be on this property anymore. I'm done. The idea of tenants in common is that you technically could sell out your interest to Frank, right? The idea is that you own an interest that is something you can convey. The same thing for joint tenants with the rights to survivorship, which could sever the tenancy, the survival of the fittest. But in that deed, what it's saying is Al and John are on title. Al dies, it all goes to John. By the recording of a death certificate, all goes to John. Now John is on title, and John, you should either do a ladybird deed, you should either retitle it in a trust, you should do something with it, because if not, there could be a probate situation on your end. So the idea is to think through the deeds, and that's why partition's a whole other thing, but that's where the deeds become really relevant, is because you could sell out interest that you have on title, or that's why it could be a random person, right? You could say, I'm done with this property. I'm selling it to random person. Now, random person and Al are on title. So that's the whole idea of tenants in common, and the right of survivorship is that survival of the fittest.
Okay, thank you. And you just cut out that last bit, but I want to go. I kind of know where you went with that, so I'm going to keep going. Okay, so let's jump real quick into this, Al. It's basically a living trust, because we do come across this a lot. So we're buying a property, we look it up, and on the deed it says that the property is in a living trust owned by Mr. and Mrs. Smith as the trustee and trustor of that trust. Okay, so one passed away. All right, in this case, one passed away. How simple is this deal now, with it being having been smart enough to put it in a trust to begin with? And what are the probate issues in Florida like in that situation?
This is funny for everybody that's watching. I have no idea how many are watching. Great, 24 on the feed are watching. So, John, on March 10th, I think it's the second Wednesday of March, I'm doing a live webinar on trust administration. I'm calling it Tricks Are for Kids, but Trusts Are Not. And the reason being is because everybody has heard me talk about this. Trusts avoid probate. Poorly drafted trusts do not avoid some kind of court thing. And what do I mean by that? So in your situation, that's the flag that you're looking for. Property is titled in a trust, and let's just say for purposes of the trust, where a copy of it is. Forget the original. You could just have a copy. And so there was a trustee. We'll just say John Smith was trustee. He titled it in his own trust, and John dies. And there's two beneficiaries. And when John died, his trust named Sally. And Sally is somewhere to be found, but nobody knows where she is. Well, why is that important? Is because she technically would be next in line to sign as trustee for the closing docs, for your contract. But what happens when John never named anybody on the trust except Sally, and Sally resigns? She doesn't want to be a part of it. And you, John, you approach the two beneficiaries because you saw the trust, you've skip traced them, you're doing your thing, and you find both of them. You say, hey, you two, Do you want to sell? And they're like, oh my gosh, we've been waiting for this day for so long. But every time we keep hearing about it, we can't. You can. And that's the idea of trust administration. Appointing a new trustee, you can appoint both of them. But the idea is that's where you need me, right? We have to go to court. We have to file a document that's to appoint somebody new. And it's not to do lawyer stuff. It's to almost appoint that person that has authority that the underwriter is going to recognize that you have as binding to a contract. And now they have authority to sell it and get rid of the trust property. But the key here with trust properties is you got to have that trust. So I keep running into these ones in Florida where there's like this certificate of trust or abstract of trust. And it gets really tricky because I had a brainstorm with another colleague attorney, and I told him, I'm like, me doing what I'm doing, I'm picking up all these like wackadoodles, and some of the ones that have been crazy are the certificate of trust. And I was like, can you figure out a way, if there's no trust, to use that certificate? And it sounds like you can, but you need everybody to sign, everybody that's on that certificate to sign. And the thing is what if they're dead? And that's the part I don't know. So it gets very tricky with the trust, but it's possible to do. I see those more. I have one right now. The trustee, so the trustee died. He named a successor trustee. He doesn't want to participate. There's 3 beneficiaries. One of them had passed, so the 2 kids. There's 3 beneficiaries. They all want to sell. Well, one of the beneficiaries has been trying to contact the trustee and saying, hey, what are you doing? You want to do, you're the trustee here. You're supposed to do what's in the best interest of the trust. And you know what? They can't reach him. They can't get him. They can't find him. So you know what we're going to do? We're going to remove him. And we're going to name the next person in line to sign the closing docs and appoint them as a trustee, because you can. There's a way, there's a solution, but you got to have the trust too, because lost trusts are another creature that rarely shows its head. I mean, it's really hard. You're talking estate planning documents, testimony of the estate planning attorney, the intent. So I could go on about this for a long time,
Yeah.
John.
Well, I love those certificates of trust, and I'm an advocate of those. And they work great as long as you don't have somebody passing away on you. So even in most states now, across the board, more and more laws are being passed that actually say that a title company, or if you're opening up a bank account for some reason, they must accept a certificate of trust and not actually able to see the trust document. So but that doesn't mean if somebody passes away, because that then opens up, as we can easily see, and as you aptly pointed out again, that opens up a whole nother can of worms. And now we have to pull the court in, and now we have to, go through all this mess. But up until that time, and hopefully we, when we're doing our deeds of trust, I mean, when we're doing our certificate of trust and everything, we don't really, run across those issues. So I just wanted to point that out, because we do teach that as a strategy in my material. Okay, so let's go ahead, and I've got just a couple of more questions, and then we'll open it up to people listening. Here's a real common question people would have. Can an executor or an executrix convey the property? So if you're talking to somebody and they say, oh, well, so-and-so passed away and they made me the executor, I can sign it. What do we need to do? What's the questions we should be asking at that point?
So the way I'm hearing it in my head is there's a personal representative executor appointed already by the court.
By the court.
And they don't just want to sell it. They just want to convey it out either by like a deed or a PR deed, right? Okay. So 2020 strikes again, and Al Nicoletti learns another little thing that happens. So I had a deal in North Florida, not the Jacksonville area, but I had a deal last year where I think it was like husband died, he had a spouse, but then she died after. And then she died, she had 2 kids. Well, anyway, it was really crazy. But it wasn't so crazy because it wasn't that many heirs. It was just weird. It was weird maneuvering. So at the time, still didn't know that title insurance was taking an order of summary as a deed on property. I would have preferred that all day. But what we did was we appointed one of the beneficiaries as a PR. He got appointed. We did a PR deed that moved it over to mom.
That's a personal representative.
Personal
PR.
representative's deed, right? It's a deed that I'm not a fan of anymore, but we'll get into that. And then when I moved it over, we then did the order authorizing sale. So I was so happy. We did it. We get the title commitment back from the title insurance underwriter. And the underwriter says, and I never heard this before, motion to confirm an authorized distribution of the property is needed. What is that? I've never heard of what that kind of order is. What did we learn? So you hear all about how the PR can do everything. They can go to, once they're appointed, they can go to the bank, they can get the money, they can open the estate account, they can now change the car title. The one thing that they definitely can't do in Florida is they can't transfer property over without a court order. Technically, a personal representative can't do that without the judge saying it's okay. And the reason it's saying that is title insurance doesn't want to do it. They review case law and stuff to see who's authorized to do it. So if you're in a state that's like that in Florida, I don't like personal representative deeds anymore. I unless it's going to one, there's one beneficiary who's also the PR, maybe, but I don't like it. It's just something I don't like it anymore. I love orders of summary. Simple, easy, find them, let them all sign. Be very careful with PR deeds. I don't think a lot of people realize that PR deeds are not the best thing that you could probably do.
Okay. And yet they are so common. What happens when we have one of the siblings, and I you know what, I'm going to skip that one because we've already really talked about it before. When one of the siblings is holding out and saying, I'm not signing, you kind of have to go to a court order for a.
You there, John?
Yes, I am.
I think it cut out for a second. We'll start the question again.
Okay. So when one of the siblings kind of either disappears or refuses to sign, how do we put this deal together?
So that is where you get into an interesting world of partition, right? And so with land, it's harder. If you find the orange grove that's $700,000, now we're talking. If you're finding the land deal that's $5,000, it's going to be really tight on numbers. It's not happening. And I learned about that last year too, that you have to have the right spreads and the right margin. But another thing, if you check the Facebook page and the YouTube channel, and now it's going to be on the iTunes and Spotify, I'll do my whole plug at the end too to make sure everybody knows where to find me. But I talk about this concept of partition. A, B, C, and D all are on title. And let's say just mom died and we haven't even gotten to that and you're thinking ahead. The idea is that if everybody was on title and you approach A and A says, I want to sell, and you approach B, C, and D and they said, no way ever. Technically in Florida, there's a way that you could buy out the interest of A and then you own it, John. And then you're just like, what's this partition thing, Al? How do we force the sale from the others, pushing it to a public auction? It's not this real function of like motion to approve sale for yourself back at the end, right? It's this idea that you own an interest, you're on title, you're pushing it out. It's kind of like a quasi wholesale in a way, if you really think about it, if you play the numbers right. But that's how it's solved. It's kind of, there's a way to buy out interest too. Or that heir A, they could just force the sale from the others themselves. There's new laws in Florida about heirs versus heirs. It just came out last year too. that talked about how I think if an heir owns like more than 20% or 20 or more percent on title, that they have a right to buy out the others, and you have to do this fair market thing. So if they don't do that, because we all know that, I mean, if the land's really expensive, they're definitely not going to do that. If it's land that's inexpensive, they may do that. But if they don't buy them out, now you can proceed forward with a creative solution. So I talk about that. It's called forcing the sale, partitions in Florida. But the cost, there's costs involved. So you got to be prepared for costs. That's not attorney's fees, a whole other discussion. But you also have to be prepared for what's to come. What's the equity? You got to break down the numbers, and you got to use title. So partitions have to be truly analyzed for equity to make sense, who's on title, all of it.
At what point do you think financially, what point does it start to make sense to look at doing a partition if you come across a deal where you can come in there and pick up an interest like dirt cheap, maybe even nearly free, because some people will just give it away?
So I think my rule of thumb in what I've seen is it's got to be at least $30,000 to $40,000.
And that sounds about what I've heard other investors who specialize in partitions. That's about where they're at too.
Yeah, whether it's a spread or the price of the property with all property taxes paid, no mortgage, no phantom mortgage, no nothing, right? Pure money.
Okay. Well, that was, so as long as we're talking about cost. So typically if somebody has to like come to you and say, okay, can you help me out with this, probate issue I've come up with on this deal? Well, I know it's going to vary depending on the deal, but can you give us some idea, just round figures of what it costs us as an investor to bring you in on the deal? Or maybe we always pass it on to the buyer in some form or fashion, but how's that pricing structure? And then how do we pay you? How do you get paid?
So the best part about all of it is the client can pay the fees and the costs, or the investor can pay fees and or costs if the client consents. So when it gets to that situation where the heir doesn't want to pay and you make your agreement, say, Al, we're fronting it to you. Great. The client is still the client. That doesn't change. I mean, we have that relationship, but we can accept the money if they consent. And when you have summary administration, so we're talking land, we're not talking homestead, but when we're talking land, that counts as an asset. So unless the land's under 1,000, then it would be 250 in cost. Land for opening a probate, you're looking at starting 350 plus whatever shipping costs, if there's a will, overhead costs that are involved for creditors, certified mail. But on a simple, no real issue case, you're looking at costs, not attorney's fees. I know everybody's like, wait, that's attorney's fees too. Costs. And if you have a situation where maybe the newspaper has to be run, maybe there needs to be other things done, maybe a maximum of about $800 you're looking at initial cost, but usually it's $350 and that's it. And then the attorney's fees vary, right? Maybe one heir, I'll do $2,000, a couple heirs, $2,500, super wacky, maybe we're getting to $3,000, extra wacky, we're talking billable time until the whole thing's over, right?
Okay. And this money that somebody's paying, either us or the client, when does that due? Can we make our profit if we're doing a double close on it, right? And so we're making and pulling out, let's say our 10,000 or whatever we're making. Are we able to pay you at that time, or do we have to pay you up front?
So the cost is the thing I really need up front, right? The 350, the 800, whatever it is, because those are things that's overhead. We really need that. Right. But the fee can wait until the end. The fee can wait until the closing. Or so that's what I normally do. It comes at a closing, whether it's from buyer, seller, if the seller agrees that the buyer can pay and consents. But sure, absolutely. That's how I've been able to do this. And people like Frank's seen this with the community I've been with in Jacksonville. This is the structure I'm able to bring, the fact I can wait until the end for this whole thing. But that's what forces me to figure out and think through this whole thing with you all, the whole pie, is because we all have to get there. Otherwise we can't get to that point.
Right. Exactly.
Yeah.
Okay, well, thank you so much, Al. So go ahead and give us what you've got coming up, or how can we like reach out to you first of all, and and yeah, just give us what you've got coming up as well.
Okay, so first of all, everybody can find me on YouTube, on my YouTube page, Facebook, YouTube channel, Al Nicoletti. I got tons of content on there on partitions, quiet title, probate, obviously probate. And of course, I have my show, which is the Al Nicoletti Show, where I interview super investors, rising rock stars, movers and shakers, and leaders of clubs in the community that are always educating people, right? And you can find me on iTunes and Spotify, and an episode drops weekly. And I'm also going to start dropping, John. I'm going to be doing my micro content on my PowerPoints that I do, because people love listening to things in the car. What we've learned from Clubhouse is I think people are a lot more auditory than we initially thought. And let's not forget, a lot of people love visuals, but then people love auditory. Yeah. And so people can find my micro content on the iTunes, Spotify that will be coming out. I have my Facebook page, my business page. I'm on Instagram at Attorney Nicoletti. The best way to get me is you can message me on Facebook. I love that. Messaging me on Instagram and just finding me out there, John. I'm constantly dropping episodes. I want to provide value to people. So I hope people subscribe to the YouTube channel and you find me on iTunes and subscribe to the podcast.
Well, thank you so much. I know we have gone way over our time limit tonight, and so I appreciate you for hanging in there. And let's do this again sometime. This is great.
I'm ready. I'm ready. I'll keep going.
Okay. Thank you, everybody. Thank you, everybody on Facebook for tuning in. And I know we covered some of the questions I just went through there. So looks like we're good to go. And we'll see you guys next time.
See you then. Thanks, John.
Bye-bye.